properly in the agenda, excuse me, in the minutes. So we're going to get started with roll call.
Steve Thomas.
Here.
Tim Dooley.
Here.
Holly Rickert.
Here.
Tom Musselman.
Here.
Cindy Scroggins.
Here.
Jeff Lawrence.
Here.
Daryl Whitworth. Jim Giroux.
Here.
Janice Menking.
Here. Thank you. All right, we're going to go to item number 4, which is public comments for, this is the time to speak for comments that are for items that are on the agenda or not on the agenda. I do have one person here who signed up for the public comment section, and that's Christina Lackey, or is that Lackey? Lackey, would you like to speak now or for a particular item that's on the agenda?
Actually, it was start out.
Okay. Okay, I'll keep it.
Cover the other two parts.
Okay, I'll bring it up at that time. Is there anyone else here who would like to make any comments at this time? Is there anyone online that's listening?
No, ma'am.
All right, thank you. All right, then we will start with the first public hearing, which is public hearing 5A, request Z2228 by Bethany McCullough to consider a conditional use permit for section 6.110 to expand the use of an STR non-conforming property located at 511 West San Antonio Street. I will entertain a motion to open the public hearing.
I'd like to make a motion to open public hearing Z2228.
A motion by Jim, second by Tim. Any other discussion? All in favor, aye.
Aye.
All opposed? Bethany, is that you? Would you like to make your presentation? Thank you.
All right. Hi, everyone. Chairman, Vice Chairman, members of the Commission, thank you so much for letting me talk to you today about my CUP application. This is my first time submitting a CUP application, so Shelby has been and staff have been most helpful in helping me stumble through this process. So hope you might bear with me. And with that in mind, my exhibits are a little crude, but I think we'll get through it. A little bit about myself. Again, my name is Bethany McCullough Ross. I'm a Central Texan, 6th generation, grew up in Austin, Texas, came to Fredericksburg growing up, and frequented the area. We recently, my sister and I, along with my husband, Aaron, who is also here, and her husband, found an opportunity to purchase a property here at 511 West San Antonio. We spent the last 10 months renovating the property for, on our own. Came up every weekend, trying to restore it to the best of our ability, and to make it more welcoming and more beautiful to the community. With that, I guess the updates made it to where we could sleep more occupants. And so currently we have an allowance for 10 occupants, and we're looking to increase that to 15 occupants. I have a large family, and so, we come down here for birthdays, we come down here for holidays, we're coming here for Christmas. And so we added, some sleeper sofas, and with the cost of this house, we, use it personally, but also want to STR it. And so we want to be able to show that we can sleep that many. So with that said, with the application, I guess staff had a few sticking points that I wanted to address with you guys. The first one being, I guess, so this is an updated exhibit for parking. The first sticking point was parking. And I guess, Shelby, this is updated from what I sent you, so you didn't quite have adequate information to make your determination. So I guess I was under the impression that we were under the 2018 code, which I believe is one off-street parking to one unit. And so I just showed 3 parking units, and so that would not be adequate. And so in staff's response, they mentioned that there is new code that requires 1 parking spot per 2 occupants. If this was the case, we have 7 spots, and so that would allow for 14 occupants. So not quite 15, but I hope this is something you can consider. Another sticking point was average occupancy for the STRs on the street around us. You can go to the next slide. This shows the compatibility and who is non-STR and who is STR and what their occupancies are. So with this information, I put together a spreadsheet that kind of displays and summarizes each STR unit and their occupancy. So if you want to go to that next slide, that's also what you have in your supplemental documentation packet that I had provided. It takes each STR unit around me and the units and summarizes their occupancy and shows that the average unit occupancy around me is 5.6. And so if we take the units that are units 1, 2, and 3, the occupancy that we're seeking, and the average of those, that would make 5 per unit. In addition to that, I know it's about compatibility, and so if you want to go to the next slide, Shelby. So there's several non-STR units around me, so I wanted to be a good neighbor and go to each one of the residents around me and knock on the door, either personally talk to them by phone or in person. And the residents with the green stars are ones that indicated that they were in support of us increasing occupancy, and I do have that in writing in the packets, either via email or handwritten, that shows that they are in support of that. I did erroneously put a star on 506 because I thought that 507 also owned 506, but they own 506 on the street over. But with that information, I hope you will consider accepting my CUP application. Thank you.
Thank you, Bethany. Is there anyone here who would like to make comments on this application?
Move to go out of public hearing back to the regular session.
All right, have a motion by Tim, a second by Steve. Any discussion? I guess not. Okay. All in favor, aye?
Aye.
All opposed? All right, Shelby, you have any comments on this one?
Yes, ma'am. Thank you. And
Thank
thank you, Bethany. That was a fabulous summary of the project. Overall, the reason why we're considering this application tonight is because this application is requesting to increase their occupancy for 2 units on the property. It's important to note there's a total of 3 units, the cottage, but that unit is not included in this request. They're only asking to increase the occupancy for 2 units, Ranch House and Stone House. And because these permits were approved prior to the adoption of ordinance number 2022-13, which was approved on April 1st, section 6.110 requires that any increase in occupancy, expansion of use, requires a conditional use permit. So that's why we're considering this application tonight. The property is zoned R2 and it is located in the historic district. The property, as I'd mentioned, currently has 3 units, Stone House, Ranch House, and Cottage. The 3 units combined have an occupancy of 10, and the applicant is requesting a combined occupancy of 15. When the applicant first submitted their STR applications on 10/20/21, they requested an occupancy of 2 for Ranch House and an occupancy of 4 for Stone House. The applicant has now requested that they be allowed to entertain guests to the max allowable amount of the previous STR ordinance, the 2018, which would allow 1 guest per 200 square feet of living space per unit. With that in mind, currently Stone House has 1,881 square feet. So the applicant is requesting an occupancy of 8. They currently have an occupancy of 4. Ranch House is 668 square feet and has an occupancy of 2, and they're requesting an occupancy of 3. Cottage has an occupancy of 4, and the applicant is not, this is that unit that the applicant's not requesting a change or an increase for. The subject tract is bordered by residences to the west and east, with a 1-unit STR to the south. Let me pull this up, that would be helpful. There we go. With a 1-unit STR to the south that has an occupancy of 2. And across West San Antonio Street to the north is a mix of residential and STR properties. 514 West San Antonio has 2 units with a combined occupancy of 6. And 512 West San Antonio is a 1-unit STR with an occupancy of 4. I think Bethany did a really good job of addressing some of the parking concerns that we had, and they're outlined in the brief based off of section 863, which is our off-street parking requirements, as well as section 5.460, the conditional use permit requirements. Based on staff's findings, we're still short on parking for that requirement. We don't believe that they meet that request. In addition, the property is located in a neighborhood that possesses an even mix of residences and short-term rental units. This property is the only property on the block that is operating 3 units. Currently, they have a combined occupancy of 10, and to further increase that occupancy would create a potentially unfavorable effects or impacts on other permitted uses in the neighborhood. That is in violation of item 11 for section 5.460, which is the review evaluation criteria for conditional use permits. The average occupancy for the units in the neighborhood is 5. It is worth noting that the combined occupancy for the 3 units that she's requesting is 15, but there are 3 individual units that all have their own occupancy load. But because all of the units are operating on the same property, staff took the average so that we could have a better understanding of how many guests could potentially be on site at one time. In addition, all but 1 property of the 16 properties in this neighborhood operate with fewer than 10 occupants. As presented, the proposed expansion of the occupancy does not meet the requirements necessary to obtain a conditional use permit per section 5.460. Given the surrounding uses and the low occupancy average of 5 per unit, an increase in that occupancy, which would result in 15 guests on site, is not compatible with this neighborhood. Item 11 from the review evaluation criteria. Furthermore, the property lacks adequate off-street parking and as proposed is unable to comply with the zoning regulations, so staff recommends denial.
Thank you, Shelby. All right, does anybody have questions or comments?
Question. And somewhere in your presentation just now, you said something about a look back at the old ordinance where one of these was approved before the new rule change, and now we're operating under a different set of rules, correct?
Yes, sir.
Right.
2 units, Stonehouse
Is
and
the
Ranch
applicant
House.
is the applicant asking us to look back and base our decision on the old rules?
I think it's a combination. This section 6.110 of the new ordinance requires that if the applicant wants an expansion of the use, they have to go through this process. So the expansion she's requesting is an increase of her occupancy based on the original ordinance that her permits were approved under.
Okay.
So I didn't fully understand the schematic that was given to us, the searcher schematic. I don't see all the parking in here. Can you, is there a diagram of the parking? All I see is on the north side is a gravel. It looks like there's only one driveway approach.
This is the revised application that Bethany presented. And here it does show the dimensions of the 2 parking spaces here in the driveway.
So there's 2 curb cuts on this property.
Yes, ma'am.
So it'll end up by being, but it's only probably 8 or 9 foot wide, so it'd have to be stacked parking.
Yes, sir. It'd be tandem parking.
Is this a piece of property that we looked at some time ago, probably before these folks bought it, when we made them move the fences and put the fences up?
No, that was,
Is that,
on the north side.
This is the opposite.
That was a different one.
okay,
That was a different. That
Yeah.
wasn't this
thank you.
one. And that other one backed up to commercial.
Okay, thank you.
And I did want to add that staff did receive 2 letters of protest and 1 letter in support of the project.
And she provided in her supplemental packet some other support.
I'm sorry.
She did provide in her supplemental packet to us.
But
Yes,
those were not all within the 200 feet.
Sorry?
Those were not within the 200 feet, did
Not
not
all.
come as
Oh.
official.
Okay.
Oh, very good.
Gotcha.
Were there 2 or 3 protests?
Miss Anna provided a correction. There were 3 protests.
That had, okay.
Free protest?
Yes, ma'am, and 1 approval.
I'm concerned about the detrimental effects on the neighborhood.
I make a motion, we deny the request for increased occupancy of this particular property.
I'll second that.
I have a motion by Jim, a second by Tom. Any other discussion? All in favor, aye.
Aye.
All opposed? All right, motion is denied. That will go to city council on
December 20th.
December 20th. All right. All right, the next item that we have on the agenda is action item number 5B. I will be recusing myself on this one, so Mr. Dooley will be.
Okay. Item number 5B, request Z 2229 by Scott Horton to consider a conditional use permit per section 3.120 to operate a STR condominium in a R3 multifamily residential zoned area for property located at 510 Miller Street, unit number 23. I'll entertain a motion to go into public hearing.
Make a motion, we open public hearing Z 2229.
Second. Motion been made and seconded to go into public hearing. All in favor signify by saying aye.
Aye.
Aye. All opposed, same sign. Motion carries. We are in public hearing. Is there anybody in the room who would like to make a comment on this particular item at this time beyond? And I need to note for all of you that the owner of this property and the applicant is not in attendance this evening. So we will have this public hearing for your benefit, and no action will be taken by this commission at this time because the owner is not here to present. Is that correct, Anna? Okay. And can you explain to the audience and to the rest of us what happens now that we've had our public hearing, and how will the situation be resolved?
So you'll hold your public hearing so the public that's been notified of the meeting can have their opportunity to speak, and you can take that into consideration. And then the agenda item will come back on your next agenda in January for action.
Will there be another public hearing at that time?
There does not have to be a second public hearing by this body. City Council will also have their public hearing on December 20th. The same thing because it was noticed
Okay,
But it will not be a city council action item
item until January.
because it has to be recommended by planning and zoning.
okay, all right. Okay,
I make a motion, we close public hearing Z 2229.
Second.
motion been made and seconded to close public hearing on item number Z 2229. All in favor signify by saying aye.
Aye. I
All
make
opposed?
a motion that we delay or
Take no action.
take no action on this item this evening.
Second.
Motion been made and seconded to take no action on this item. All in favor signify by saying aye.
Aye.
All opposed, same sign. Motion carries 5, 6, 7, 8, 0. 5, 7, 0. 2, 4, 6.
Seven.
Back, Janice.
And I get that. Yeah, well, I'm not counting myself.
Thank you, Tim.
Yes, ma'am.
All right, we're gonna go to, public hearing 5C, request Z2231 to consider proposed text amendments to the city zoning code regarding short-term rental definition. The proposed text amendments are for the following sections of the city zoning code, section 2.100 definitions. I will entertain a motion to open the public hearing.
Make a motion, we open Z2223.
Motion by Jim, second.
Second.
Tom, any discussion? All in favor, aye.
Aye.
All opposed?
Madam
Oh.
Chair,
Yes, sir?
please have the record note that Cindy has
Correct.
confused.
She's got that. It's Cindy set down, okay.
Thank you.
All right.
Madam Chair, one other clarification, I know Attorney Jones came by earlier and gave a little bit better definition of who should and shouldn't recuse themselves. I was a little bit confused about it. I mean, you recuse yourself.
If you have an STR B&B or an STR accessory, either operating one or you have a pending application for one of those types of STRs, you should recuse from this item. That's the reason that the one member has recused herself, that she has an STR accessory. STR accessory is when you live on the site and you have a guest house or an accessory dwelling unit on the property that you rent as a short-term rental. An STR B&B is when you live on the property and you rent rooms within your main house, like a traditional bed and breakfast. Those are the two types of STRs. Those definitions are ones that are being considered for amendment by City Council.
That cleared everyone then?
Cindy, all right?
Okay.
All right.
That answered it. Thank you.
Okay. Anna, would you like to make the presentation for us then?
So this evening we are reconsidering the text amendment just to two definitions, and this is because of a U.S. Court of Appeal out of the Fifth Circuit that issued an opinion striking down portions of the New Orleans short-term rental ordinance as unconstitutional. And because Texas is one of the three states included in the Fifth Circuit, the court opinion is binding to us in Texas. So in 2019, the city of New Orleans adopted a residency requirement for STRs in residential neighborhoods, much like we have done. And under the ordinance, a person could only receive an STR license if the STR is located on the same lot as the owner's primary residence, as evidenced by a homestead property tax exemption. Following the ordinance revisions, a group of property owners sued, and it was determined by the court, the appeals court, that the city's resident requirement violated the Dormant Commerce Clause by discriminating against interstate commerce. And the court agreed with the property owner's argument, holding that the ordinance precluded out-of-state property owners from participating in the STR market in New Orleans. So the court held that there are other non-discriminatory alternatives that the city could have used to achieve its policy goals of preventing nuisance, promoting affordable housing, and protecting neighborhoods' residential character, which all should sound very familiar to you, as that was the intent of our ordinance as well. So according to the court, the same goals could be achieved by increased enforcement, increased local taxes on STRs, a requirement that STR owners have a non-resident operator stay on the property during the night, or by capping the number of STR licenses available for any given neighborhood. In the court's words, the city has many options to address the problems caused by STRs in residential neighborhoods, but it chose the one that the Constitution forbids. So staff has worked with the city attorney to propose a text amendment that would modify the residency requirement in our city's current definitions of STR B&B and STR accessory to conform with the court's opinion. And as you'll see on page 59, it is pretty straightforward. Current language says that a short-term rental providing transient guest lodging accommodations for compensation within a lawful guest house on the same lot as the primary or as the property's owner, principal residence, as evidenced by homestead exemption. So what we're adding, we're keeping that, but we're also adding or the local contact person, as evidenced by a sworn affidavit of principal residency. And then we actually add a little bit more for purposes of this definition. The term principal residence refers to a person's primary or chief residence that the person actually occupies on a regular basis. And so that's for the accessory STR, and then for STR B and B. Again, in a very similar manner, defining an STR within the room, or sorry, for accommodations, within the rooms of the primary structure, which is the principal residence of the owner or the local contact person, again, with the same definition or requirement for a sworn affidavit. So in our opinion, this gets us around the constitutionality issue because it's not, it can be an owner-occupied structure that's rented out as a B&B, or the owner can live there and have an accessory, or they can deem their local contact person to live on site, require them to live on site, and then essentially manage the property, which was the reason that we allowed R1 to have STR B&B and STR accessory by right. Right, the idea was that somebody was going to be on site to manage and keep it under control, an on-site property manager. So it's pretty straightforward and minimal, not trying to open up the entire ordinance, just taking care of this very particular issue, default with the ordinance.
The bottom line is we're adding a designated agent. In
Yes.
place of it has to be a owner.
Correct. But a full-time
They have to live.
So,
How do we prove that?
yeah,
well,
I have some
we
questions.
have a sample affidavit that Daniel's come up with based on another state agency's similar affidavit.
so are you effectively making a short-term rental accessory definition a combination of an STR and an LTR because you're asking a designated person to live there full-time?
Could be.
And my second question on this particular definition, because of the change in the way you're having now a local contact person on site, right now it says the guest house shall not exceed the size of the primary structure. So you're basically saying I've got to have a local contact person use the big property, and I can only rent out the smaller property if I have two buildings on the same parcel.
That's not changed, correct?
That was correct.
Does this apply only to R1 residential zoning?
No, the
No.
the definition applies. So R1, R2, R3, even the commercial districts, say that accessory and B&B are allowed by right, but this definition is going to apply to all of those.
Okay, so I'm a property owner that has an STR or an STR with an accessory building, and I don't live in town. It's not owner occupied, but I have an agency that takes care of my property for me. Am I now going to have to find somebody to live on the property? According to the way this is written, that's how I read it.
If you want a new permit, right, because right now we wouldn't have issued a permit to anyone unless they were in for just these two types of B&Bs. We're not talking about unoccupied. We're just talking about these two types. So if you wanted a permit for one of these two types, yes, you would either have to confirm that you live there as an owner occupied or that your local contact person. It can't just be Guest House Schmidt. It has to be John Smith with Guest House Schmidt lives here, and he's going to sign an affidavit, for example.
Okay,
So this applies to both R1 and R2. I mean, every zoning district that has STRs.
For the record, there are very few of these. This is probably the least.
how many do you know?
We don't exactly know because we've had so few new ones. And before, right, in the old ordinance, there weren't these distinctions. Shelby probably has a better idea, but it's not a large category.
So to be clear, to date, we've approved no STR accessory or STR B&B permits. We have approved none. So this definition hasn't been applied to any permits we have currently. Now, if the question is, do we have current properties that are owner occupied in the main unit with a guest house being rented out? prior to 2022, I think in 2020, when we first ran those numbers, we had 20 or fewer of those specific type of properties.
All right, now what happens at renewal time? Get their permit renewed,
They would
and they are non-compliant with this new verbiage.
Well, in this case, it's opening it up. It's not closing it down. It's not restricting it. So we could see, right, more applications.
Okay. All right.
Okay, so
That's
we're
good.
in the public hearing, so let's get some of the public comments
Yeah.
and then we'll go back to the questioning.
Well, thanks for the explanation, because it's
Yeah, that might have helped some of the
And I
public
could just,
comments.
I
too.
apologize. I
Yeah,
know
that's okay.
these public hearing letters have to go out in advance of the staff recommendation before we had our final language. So I know it's very generic and people are like, what's going on? What am I protesting or approving? So I apologize that it's so vague. But we did try to update our website and then link to the agenda once it was posted so you could see the language. It wasn't meant to be confusing, but it is confusing.
Make no mistake.
Right. So Christina, do you want to make any comments now?
Yeah,
Sure, come on up.
actually, in the presentation, you answered a lot of my questions. I appreciate that. I was looking for answers to questions, basically, as far as me addressing the board. And I think by, you letting us know that, yes, the person does have to reside there and they have to be there overnight. That was one of my questions as it applied to unoccupied STRs in R1 and R2 zoning. Okay, so I'm thankful to know that. I do have a question about the qualifications for homestead exemptions on some of these R1 and R2 STRs. If you happen to go to the Gillespie County Appraisal District, you'll find out that a good many of them are owned by LLCs that are actually out-of-town LLCs. In my particular area, which is Creek Street, the one on the west side is owned by an LLC in Mansfield, Texas. There's one to the east that's owned by an LLC in Austin. But yet they've been able to get homestead exemptions on this, even though they're unoccupied and there's no one there, and they're an out-of-town owner. Now, interestingly enough, and my sister back there, raise your hand, Kathy, has the documentation on it. If you look at the Gillespie CAD website, you'll see that there are a good many of the STRs in town, yes, that are owned by LLCs, but in addition to them having 100% ownership, there's also on the website listed ghost partner or ghost owner that owns 100% of the property also. Okay, I don't know who's been entering this in the county website, but is this how these homestead exemptions are being acquired by someone who does not live in this county or in this municipality? And by that token, they live in North Texas. They live in Austin. They live, fairly far away. How are these homestead exemptions even being acquired? Because nobody's in these houses.
You don't actually have to live in the house to be home exempt, but you can only have in Texas
One.
legally one.
Right.
Right.
So that might be their only one.
That might be their only one.
Okay. That's what I'm looking for. Explain it to me. Because I do understand that you have to be a partial owner, and I didn't know if the ghost partner was considered a partial owner, and we don't know who they are because, they seem to be quite prevalent. Kathy, did you know how many on that sheet of paper? Yeah, quite surprising. I'm thinking, well, is this new for, are we getting people in to check out the ghosts?
the ghost owners. Anyway, so that sort of is something to think about.
Have you spoken to the appraisal district about that?
Anyway, I don't believe I have anything else because I said, I'm sorry, you answered a lot of my questions. Also, I will ask this, because I have 3 STRs around me, all of which are now unoccupied. They're STRs unoccupied in R1, and there's one up the street that's just a couple of doors down that's actually R2. I will know whether someone's in there or not because it's pretty obvious. When this is being rented on a weekend basis and there is no one else in that house if this goes through, and if there's no one residing there, who do I call? The code enforcement officer?
It only applies if it's 2 units.
What?
Would you?
Yeah, it just applies to R1, R2.
2 units on our.
I'm sorry, what?
I'm sorry, I didn't quite follow. So this isn't going to impact any of these unoccupied as they are right now. This is only for new STR accessory.
Okay, yes,
B&B.
that's another question I had. Will it apply when they change owners?
No,
This isn't impacting the unoccupied at all.
This is just an accessory dwelling unit, 2 units on one piece of property.
Well, no. What I'm saying is this is an R1 zoning, okay? Because these are STRs unoccupied in R1 zoning.
Okay.
Okay. So basically, do they not in R1 zoning now have to be considered a B&B and have someone present if this is approved?
No, ma'am. The ones that exist today can continue to exist.
Okay. Now, what happens when that property sells?
If it sells and the new owner wants to change and they want to live there and then rent out a guest house, or if they buy it and they want to have a long-term contact person live in the main house and rent out the ADU,
right,
this would apply.
That applies. Okay. So when it changes hands, that's when it starts applying.
If they elect.
Right. If they elect,
if
they elect to become a B&B or whatever. Yeah. Hopefully, maybe not. But, we'd love to have some neighbors back in the neighborhood. But anyway, seriously, you answered most of my questions. Okay. Thank you very much.
Thank you.
Good.
Is there anyone else that wants to has any questions or make any comments? Yes, sir.
How are you doing this morning? My name is Matt Brennan. I'm Cozy Vacation Rentals in town. We manage probably 200 properties or so here, over 40 full-time employees. I know this is planning and zoning. We were at a city council meeting, about 4 or so weeks ago. There was a task force that was designated. We discussed that everything would be on pause until this task force met with constituents from all angles from the city, from real estate, from people who, have a different opinion on STRs, people who are in a management company, for folks who, self-manage, etc. And to see this language, I have a big cause for concern this evening upon especially the sale of new property. I have a lot of questions and confusion. Not that I don't know if we have enough time today to answer all of it, but there's a big gray area, obviously, in this language on what happens when someone buys and sells. What happens, are we going to require, my staff to live on a property full time? Someone already brought up, but we're going to have to build accessory dwellings to put someone on the house, the property full time. I mean, there's a lot of unknowns here. And from my understanding, we were supposed to be pausing until we came together as a community to figure out a solution. It seems like we're still driving this forward. And I really need to understand the why of it. And this language is pretty damaging to a lot of local employers. I mean, we already had the economic impact study last year. 2,000 people depend on tourism here for work in Fredericksburg. It's the largest employer base in this town. And we really need to figure out what to do here. But I do have a big concern with this language that's being proposed, and I do protest it until I can learn more and get a lot of questions ironed out. And I ask to have this pause this evening until we can really figure this out and have a clear understanding, because the letter, I know it wasn't your intent to be vague, but I've been answering questions for 2 weeks from owners that we manage on what is this about, and I really don't know until this evening. And my ask is, let's pause, let's understand what this is about, what this could big drastic impacts that a simple language change can have here, because there can be some detrimental impacts if this is passed this evening. So again, I would appreciate if we could protest this, pause, and let's understand better as a community, and let's let the task force come together to figure out how we best do this. I know that's at a city council decision, but thank you for your time this evening. I know this is a complicated issue, but thank you.
I think this is a Daniel issue. He needs to address that.
Well, can I ask a clarifying question and allow staff to respond, which might kind of narrow this down a little bit? My understanding from reading this is that we are modifying 2 types, and we are actually expanding the opportunity
In both those types.
in both those types. Our current ordinance as written, both of these types, the owner must occupy the property, correct? To qualify for these 2 types. Correct. Right? And now we're expanding that to say either the owner can occupy it or they can have another designated person occupy it on their behalf. Correct. Is that essentially what we're changing because of the circuit court's order?
Yes, ma'am.
Okay. And are we changing anything else about the current ordinance other than these 2 definitions?
No, and I will say, because the mayor said it on the record, because he did set up a task force, that is true, and they are meeting and have met as recently as today. But he wanted this particular issue because it left us vulnerable to lawsuit.
Correct.
So he wanted it laser focused, and that's what we attempted to do.
And these 2 definitions apply to permits applied for after April 1st this year when the ordinance went into effect. Is that
Correct?
so? This doesn't affect grandfathered non-conforming activities at all.
And it doesn't affect non-owner occupied
It doesn't affect the
current,
other
the other
definitions
ones.
either. We have those several other
Those
definitions in there.
grandfathered.
This is just the 2.
Right.
These are the only 2 definitions in our current ordinance that require owner occupancy, correct?
Yes.
Okay, and now we're adding that another person can occupy and qualify this, and it doesn't have to be one. Yes. Okay, thank you.
Does that clarify any for you, sir? That it doesn't affect your non-owner occupied that were grandfathered?
It does, in my still with the future if we're buying this here. I understand, but still there's probably the conversation that needs to be done how to bring water.
Yes, please.
Sure.
Yes,
Come on up.
please.
I'm Belinda McDonald, a resident of Fredericksburg, and I am on the SDR task force. I'm here more for clarification. The task force is aware that this was an item that was going to be dealt with. It was a legal issue. It's really, as far as what's been put out in front of us, it's not, it's on a parallel track, but not on the same track. Now, I would welcome the opportunity to have this as part of what the STR task force is doing. I certainly think it folds into a lot of things that we are doing, but I want to be transparent that this is not anything that we have dealt with. That's all I want to say.
Thank you.
Thank you. Sure.
Rachel, and I'm not going to claim her all over, but get up to the microphone. You know, when you read the paper, over and over again, you see people talking about the shortage of long-term rental find myself speaking out in favor of this because I do know which way I want to go. But could this not be an opportunity to provide more long-term rental properties to people if they are going to be
Designated.
the designated caretaker, okay?
Absolutely.
That B&B or whatever, okay? Because maybe this issue can bring about a good change, okay? I think that's probably a real plus, right? Because this way it would open up for long-term rental property to people who need to work in our community.
And the reality is on-site supervision is always going to impact.
All right. Anyone else who wants to make comments? Yes, sir. Y'all come up here, and we have people who are listening online, so if you would come up here, I'd appreciate it.
I too am on the task force, and if the task force decides that, months down the road, whenever it's making recommendations, that this doesn't stand the test of time, then it could be reexamined along with all the other things that are going to be reexamined. But this is important as a legal matter to close what is essentially a loophole now. We cannot enforce the language we have according to that court case. So that's why this is being pushed outside of the track of all the other things. It isn't a rush around the corner or beating it to the finish line. It is needed to make our ordinance as tight as it was originally drafted. Thank you.
Thank you. Did you want to make a comment?
I just had a question. Excuse my comment. I have B&Bs popping up all over my you were next. I'm an R1 caster in working at 5 o'clock. This is what we're going from an office in the
I will let Anna answer that question.
Yes, ma'am. The ordinance that was passed in March of 2022 prohibits new unoccupied in R1 with a small carve out for some exceptions. If a property is essentially surrounded by, shares two property lines with permitted STRs, they can apply for a conditional use permit. So there's a window if they meet some criteria, they can apply, but it's not a guarantee. But otherwise, yes, they've been prohibited in R1, unoccupied. If they share two property lines and 75% of the properties on the block facing the same street have valid unoccupied STR permits, they could apply for a conditional use permit.
We call it the donut hole.
All right. Anyone else want to make comments? Come up here, please.
So my name's Libby Bergo, and I'm an STR occupant owned, or whatever, STR. And now that we're asking all these questions, one of my questions is, what about if the property is sold? Does it get grandfathered in?
So the ordinance that's in place today has a transferability clause. So they are allowed to transfer as long as they transfer within 10 days of the sale of the property and they obtain the necessary inspection.
Thank you. All right. Anyone else? Yes, ma'am.
My name is Sally Clark, and I just like to address what the lady was saying about the long-term rentals. My husband and I moved here in 1985, and my cousin advised me, she said, you be there when that newspaper comes out on Wednesday afternoon and you grab it. Because she said there won't be more than 4 or 5 long-term, we just called them rentals in those days, of houses that we wanted a 3-bedroom, 1 bath at least. And she said they'll be gone by Thursday morning. And she was right. That was 1985. We'd never even heard of the term bed and breakfast. None of that existed. Nobody was doing that. Ken Panop was the first person to bring that in, and that was somewhere along the late 80s, early 90s. And the long-term rentals, watching the newspapers, that situation has never changed, and it's not going to. I hear too many horror stories from my friends who do have long-term rentals of, well, yeah, you make money for a few years and then you get that one person in there that does $60,000-$70,000 worth of damage, and there went your profit. So they love the short-term renters because they don't do that kind of damage. They just don't. The houses stay in better shape. You can drive up and down the street and almost pick out that house is a short-term rental. That house is a B&B. That house, because they look so nice. The yards look nice. They look appealing. Their lawns are mowed. There's a chair or two out on the porch. You can just tell. And the appeal is wonderful, and it evaluates the property values on the whole area. So I'm in favor of the short-term rentals there. And I live in a neighborhood that is R2, and it's gone mostly short-term renters now. I don't have any problems. I don't have anything to complain about. Every once in a while they'll get too loud, and I'll think I'm going to have to call the police. And then I look up and I the clock, and it's 8:30. And I'm like, well, okay, fine. They can have another hour and a half, and they do. And by 10 o'clock,
And you partied past 8:30, haven't you?
well, not in a while, not for a year or two, Tim. Anyway, that's all I would like to say. Thank you.
Thank you.
Sally.
Yes, sir. One, two more, and we'll see what we've got. Okay.
Hello, and thank you for taking my comment. My name's Jeff. I'm a fifth generation resident of Fredericksburg, and I own some properties here in town, and I have some rental properties. And yes, you do run into some problems with the rental properties. That is true. But it's not everyone, and over time it comes and it goes. My property has been taken very good care of. Just one comment. How are you going to put a teacher in an STR? How are you going to put a nurse in an STR? I have children who are going to public school here. Very hard to find teachers. Very hard because they cannot find housing. Thank you.
Thank you. Thank you very much. All right. Thank you all for your comments. I will entertain a motion to close the public hearing.
I'll make a motion to close public hearing on this. Second.
Motion by Jim, a second by, who's that, Jim?
Jeff.
Jeff, thank you. Yeah, I know, you're usually over here. Any other discussion? All in favor, aye.
Aye.
All opposed? Anna, you have any other comments? All
I
right.
would just note that we did receive several 71 comment cards, and I uploaded those for you to see because 77 actually.
You got an email?
It's in your email.
Oh, some of them didn't upload.
Let's see, yeah, 77 total. I can tell you the categories of protest, approved, and undecided, but I think you really have to read the comments because somebody would say, I protest because I don't want more STRs, and on the flip side, somebody would say, I approve because I don't want more STRs. But to say that at least 77 people have taken the time to write in.
All right, we're on action item number 6C, discussion, consideration, and recommendation regarding request
I have some questions.
2231. So you have questions?
I have 3 questions.
All right.
Number one, Daniel, did you prepare this revision?
Anna and I worked on it together. Yes.
So my second question is, can the 24-hour contact person be a long-term renter?
This situation.
They would need. I guess you could call them that, yes.
Okay.
I mean, they would need to reside on the property,
Okay.
whatever arrangement they do that under, whether it's,
I'll give you,
I mean, that's between the property owner and that person to figure out the dealings of how they want to arrange that, but that would,
okay, as
that'd be a
long
good
as then they are
explanation.
designated as the contact person.
Right, and so the current ordinance requires it to be the principal residence of the property owner, and a homestead exemption is sort of documentary evidence of that. So we have added an affidavit of residency for a non-owner that's going to occupy it as a residence to essentially swear that they live there for whatever time period, and they can support that with evidence. A laundry list of things, including the driver's license, mail, utility bills, things like that, renter's insurance, whatever, something to show that they reside.
That's their spot.
Yeah.
Okay. Number 3, my third question is: must the local contact person be on the property or available whenever the STR is rented?
Yes. I mean, that's the definition of the local contact person. I don't know if they need to be on the property the whole time that it's rented, but they would need to be. I mean, they could go to HEB and they could do their errands.
If they go out of town, they go to San Antonio or Austin, they just have to be reachable.
Well, this gets back to our definition of the responsibility of the local contact person. I think that may be considered for amendment in the future, but they have to respond within a fixed period of time and take remedial steps to alleviate any concerns.
Okay. Because if one thing we're trying to do, if we're saying that, okay, you've got an accessory building and you're renting your big house and you're renting the accessory building to a teacher, okay, then we're providing some housing, but then what restrictions are placed upon the person that is the local contact person?
They have to conform to the rest of the
Regulations.
ordinance. The response time and everything's in the rest of the ordinance.
Also,
If
just
they're
for-
designated the local contact person, then they're the person who's responsible for complying with the ordinance.
Also, just for clarification purposes, the designated agent or the owner occupied has to live in the larger of the 2 units. So you can't do what you just described there. ADU's been rented to a teacher. It has to be the bigger unit. Is that correct?
Yes.
It's not an SDR then if you're renting.
No. Wait. On the short-term rental accessory, if you read the language, the guest house shall not exceed the size of the primary structure.
Right.
Correct.
So it's the ADU, it's the smaller unit.
It's a smaller unit.
The smaller unit can be an STR, not the bigger.
Right.
Yeah.
But if you're putting
You
a
gonna
teacher-
clarify? Go ahead.
That's correct, but I would say we don't, that's all it says. And we do have the 10,000 square foot requirement in an R1.
Right.
For example, you have to have that many square feet to get an ADU. Now, right, you could have a 2,000 square foot house, primary house, and a 2,000 square foot
Yeah,
ADU.
they could be same size.
Correct.
Here's another stupid question that I'm famous for. I assume then that the local contact person could live there for free.
Doesn't matter.
It doesn't matter.
Not our
How did they prove it?
Utility bill.
Nuh-uh. The utility bill.
It's not on
If they don't have to have the utility bill, if the owner pays the bill, the utility bill, and they're living there for nothing, they're not going to have a utility bill, are they? Well, driver's license or, well,
Mail.
no.
Is mail one?
Huh?
Receiving mail
No.
at the address one?
We also put any other document that's approved by city council. So if we get into a situation where they've got something, eccentric that's not on the list, but it would demonstrate, city council would be able to accept that as proof. I mean,
Yeah, just,
we're trying to, kind of figure out a way to
I know,
demonstrate this
but
without being
You got to think about that
can
too.
I read the list of the other documents so the public can know some of the items that are also listed? A residential rental or lease agreement would suffice, an income tax return, a renter's insurance policy, an automobile insurance policy, or other acceptable documents as approved by the city council. So there's room in here for city council to approve other ways to prove that up.
You can have a
It's
rental
not
agreement
limited.
with no.
Yeah, you could have a zero cost rental agreement.
Okay.
Yeah, you can do that. Okay. I move to approve
Next amendment.
Z2231. Is that the number?
Yes.
I move to approve Z2231 as presented.
I'll second that.
A motion by Polly, second by Jim. Any other discussion? All in favor, aye.
Aye.
All opposed? All right, motion carries. All right, thank you all for your comments. We need to go to item number 3, approval of our meeting minutes from the last meeting.
Make a motion, we approve those figures.
With
What,
the,
I got it.
yeah, I've got, I already sent one to Shelby.
The one for, wait a second, with David
The one with
Turpin,
your recusal.
I recused.
Yes.
I did not vote. You got that?
I got that. Got you covered, buddy.
All right. Any other, did you have another?
That's
That's
it.
the one change?
That's just that one change.
All right. So Jim, you want to change your motion?
No.
Motion as approved, is that?
Yes. Approve with the corrections in the amendments.
All right, have a motion by Jim, do have a second?
Hold it.
Okay,
Was the meeting on November 7th or November 9th? It's on the 9th. So change the meeting date at the top to November 9th.
you know that because that's when you broke your arm.
I do.
Okay, I think it's a motion. Do we have a second?
Second.
Oh, have a motion by Jim, a second by Tim, any other discussion? All in favor, aye?
Aye.
All opposed? Anna, you have some comment, your report?
I just want to give you an
Number
update.
7A.
City Council met on Tuesday and they approved the 2 conditional use permits that you also recommended approval of, so for Cora and Orange Street. And then the middle school campus zoning was approved as well. And I also want to let you know that this evening is Daniel's last P&Z meeting.
I know, it's okay.
Thank you. He will be missed.
Thank you for all you've done for us. We appreciate it. We're gonna miss
Yeah,
you.
no. You've done a wonderful job.
Yeah.
You really used to sail through the meeting a lot faster when you showed up. But
And we could get away with all kinds of
we're really
stuff.
glad you're here.
And we look forward to seeing you across the
Across the
street.
street,
Yes.
yes.
Good luck.
Good luck.
Your
We
new
wish you the
endeavor.
best.
Yeah,
Wish
thank
the
you very
best.
much.
You bet. You will be sorely missed.
Motion to adjourn?
Oh, is that all you had?
What?
All
That's
right.
Were you done?
I'll make a motion, we go at home.
All right, motion by Jim, second by Jeff. Any discussion? All in favor, aye?
Aye.
All opposed? All right. We are adjourned.
Merry Christmas, everybody.
Same to you.
No sidebar?
Yeah.